Thomas A. Lenz is a partner with Atkinson, Andelson, Lawyer, Rude, and Romo, AALRR, a full-service law firm with over 200 attorneys in 9 offices throughout California. AALRR represents both private and public sector clients with emphasis in the areas of employment, labor, construction, education, real estate, water, general business and business litigation, corporate, and taxation. Mr. Lenz works out of the firm's Pasadena office. Since he joined AALRR in 1992, he has handled a vast array of complex labor and employment matters, often on the cutting edge of developing legal issues in a variety of industries. He handles all aspects of labor and employment law issues and heads the firm's traditional labor and National Labor Relations Board practices and works with employers in all major industries across California and the West. Mr. Lenz served as chair of the Labor and Employment section for the California Lawyers Association, formerly the State Bar of California, during the 2017 to 2018 term. He serves as an adjunct lecturer teaching at the USC Gould School of Law. He is frequently consulted by the media on workplace issues. Information on his media activity and articles he has written appear on the firm's website, www.aalrr.com. Mr. Lenz may be contacted at tlenz@aalrr.com or 626-583-8600.
Hi, I'm Tom Lenz, and it's a pleasure to be here today through the Center for Continuing Education to talk about the National Labor Relations Board and to provide this update on NLRB cases, guidance, and rulemaking. I'm an attorney practicing labor law and employment law with Atkinson Andelson in Pasadena, California, and I work throughout California and the Western states on behalf of employers. Today, I will be providing updates and perspectives on a number of labor law issues. And this is a time of change. This is a time where the law is developing. There have been recent changes, and practitioners in the area, regardless of who you represent, should expect further change. So I will be talking about areas where I foresee changes in the legal standards. We'll be going over updates and perspectives on terminations for protected concerted activities as well as union activities, workplace rules and policies, the duty to engage in bargaining with a labor union during the COVID-19 pandemic, because there have been some nuanced changes to the rules. And then there's also an update to be provided on rulemaking, hearings conducted by Zoom, and workplace elections, where the opportunity to vote in person has been compromised by the pandemic, and there's been greater reliance on mail balloting. So we'll begin with protected concerted activities, or as we know in the labor law field, this topic as PCA. And protected concerted activities are rights that private sector employees typically have, even if they are in a non-union environment. In other words, if they do not have a union representing them, they may still have rights protected by federal labor law. So this is something that employers need to know about because they may believe that if they are non-union, that the labor laws don't apply, but they do. And employees have rights which have received attention over recent years and will continue to receive important attention, if not expansion of rights, in the new administration, which is taking hold and has set some goals for expanding the rights of employees in the workplace. We'll talk about the summary of statutory basis for these rights, new standards for when outbursts by employees lose the protection of the Act, the National Labor Relations Act, that is, and a review of PCA termination cases. So where does the right to engage in protected concerted activities come from? It comes from Section 7 of the National Labor Relations Act, which provides that employees shall have the right to self-organization, to form, join, or assist labor organizations, that is legal parlance for unions, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection. So it doesn't necessarily have to be union oriented in terms of protected activity, but if it's about mutual aid or protection, in other words, something that affects perhaps two or more people, it may well have legal protection. There is also the right to refrain from such activity, which is important because employees have the right to say, no, I do not want to participate in this activity. So Section 7 is the cornerstone of federal labor law. So even in a non-union setting, Section 7 grants employees the right to organize on behalf of a union, engage in concerted activities for mutual aid or protection, or to refrain from such activities. And I think it's implicit in organizing and refraining that employees have the right to say, no, I don't wish to be represented by a union that currently represents them. So again, this cuts across the private sector, and employees in a company with or without a union have these rights. So concerted in connection with these Section 7 rights means engaged in or with the authority of other employees, and not solely something on behalf of an employee, him or herself. If an employee simply says, I want this or I want that in the workplace, that's not concerted, it's individual. But if it's, we want a pay increase or we want to change things around here, that could well be concerted. Protected, if it's for mutual aid or protection in the workplace, these are things that an employer needs to watch for in the things that employees say and do to ensure that an employer does not violate the employee's rights. There can be unlawful discrimination or retaliation, which violates Section 8A1 of the National Labor Relations Act, if an employer's actions discriminate against an employee because of their protected activity. But it's important to note that not all concerted conduct is protected. And this is an area where I expect the law to change even more than there's been in, let's say, this case reported right here, General Motors. General Motors came out in the middle of 2020 during the Trump administration. And now that President Biden has appointed his choices to the National Labor Relations Board, the politics of labor law will take hold. And that's not to go political in one direction or another in discussing this subject matter, but it's simply to say that the tides of politics affect the enforcement and goals of labor law. So the General Motors case, which is a Trump board case, addressed some new legal standards in cases of alleged retaliation and discrimination where employees were disciplined for misconduct. And the case applied a stricter version of the burden of proof test that is used to determine whether there has been a violation of the law and a loss of legal protection under Section 7. For many years, the National Labor Relations Board has followed the standards set by a case called Rightline. And in the Rightline case applicable to retaliation and discrimination, the burden that was established is that the general counsel, in other words, the attorney prosecuting for the National Labor Relations Board, must show that the employee claiming to have engaged in Section 7 activity actually did engage in such protected activity. Secondly, that the employer knew of that protected activity. And third, that the employer had animus against that Section 7 protected activity. The burden then shifts to the employer to show that the employer would have taken the same action against the employee even in the absence of protected Section 7 activity. In other words, the employer would claim that I would have done the same thing. I would have fired this person. I would have given them a disciplinary warning, whether or not they supported a union or whether or not they had made a pay demand. So this is important because the Rightline standard has existed for over 40 years now. And it's become really a major factor in how the National Labor Relations Act and its protections are enforced. So in the General Motors case, the board looked at when do employees lose protection of the National Labor Relations Act, and they overruled a longstanding case called Atlantic Steel, which applied a 4-factor test to determine if conduct was such as to lose the protection of the law in cases of workplace outbursts. That prior Atlantic Steel standard looked to the place of discussion, the subject matter of discussion. Let's say an employee cursed out a supervisor and work, and maybe it turned into profanity. What was the nature of the employee's outburst? That's factor 3. And then number 4, outburst was in any way provoked by the employer's unlawful activity, or was this something that came straight from the employee? So provocation might actually provide the employee justification leading to the claim of misconduct. Well, the board overruled yet another case, Clear Pine Moldings, which dealt with picket line misconduct and generally inappropriate behavior by employees. So there is this change in standards that the Trump board really provided to employers. It was a gift to employers to say that in order for the NLRB to find that the employer violated the law, that there needed to be a really tight causal relationship between the employee's protected activity and the employer's adverse action. So the NLRB began to require more direct evidence of nexus, general union animus or animus against protected activities. And that flowed from a 2019 case of the Trump board involving shig-free properties. A number of people have asked how that's pronounced. I've been told it's shig-free properties. So in requiring more of a tight nexus between protected activity and the employer's activity, this is making it harder for an employee to claim unlawful retaliation or discrimination. So I'm expecting that the Biden board is going to perhaps move away from shig-free, if not General Motors. And it's also important to note that prior to shig-free, another 2019 case, Electrolux Home Products from the Trump board, the board overturned an administrative law judge's finding of discrimination and held that pretextual reasons for termination are not sufficient to establish an employer's unlawful motive under Rightline. So bottom line is, if an employer raises the General Motors test because of misconduct by an employee who alleges discrimination or retaliation, the employer has a good chance of success defeating causation. It's a tougher case for employers, but the Biden board and the General Counsel recently installed by NLRB indicate that they want to, I think, take a different point of view. The Biden administration is looking to protect more employee activity, and to protect union organizing. So I expect that the General Motors standard and some of these tweaks to the Rightline standard that I've mentioned, Shig-free and Electrolux, will be cast aside so that a broader scope of employee activity is protected. And with that, I move to another aspect of protected activity, which has in years past caught employers by surprise, particularly in the non-union workplace, where again, non-union employers have felt that they're not regulated by labor law. Maybe they are unconcerned with it or simply unaware. But rules and handbooks, particularly during the Obama administration, were a big area for scrutiny and legal challenges on the basis that rules and handbooks infringed upon employees' Section 7 rights, chilling those rights, forbidding those rights, actually causing employees to be disciplined for exercising those rights. The Trump administration addressed those standards from the Obama board. The Trump administration made it easier for employers to implement broad policies regulating the workplace. Again, the change in political administration is going to affect the legal standard, and I am expecting employers will be again under greater scrutiny to explain their policies as employee rights expand. So how can this be? Section 8A1 of the National Labor Relations Act provides it shall be an unfair labor practice for an employer to interfere with, restrain, or coerce employees in the exercise of Section 7 rights. So maybe you don't have a case where an employee is actually proven to be impacted. But what NLRB has historically looked to is whether what an employer does would tend to interfere with, restrain, or coerce. So tending to interfere with, restrain, or coerce means it could be purely theoretical, yet still a violation of the law. The Trump administration in 2017 ruled in a case called the Boeing Company that maintenance of a work rule is potentially lawful, subject to a several factor test. The board under Trump overruled a longstanding case from Lutheran Heritage Village, Livonia. That is a mouthful and a long case name. But the Boeing case gave employers green lights to reassess, re-implement policies that might have been unlawful during the Obama board's challenges. And there were many across the country. Cases that challenge policies, let's say solicitation and distribution activity in the workplace. Let's say conflict of interest when an employee is supporting a union as well as working at the same company, or maybe an employee is moonlighting. Confidentiality and use of information related to the workplace, particularly if it's wages, hours, working conditions type of information, which employees have the right under federal law as well as California law to talk about with others. The board took a very aggressive view of such policies, again, loosened by Boeing. And I expect that the General Counsel and Biden board will try to reverse what the Trump board has done in Boeing as well as in the Walmart case. In the Walmart case, the policy and practice at issue involved restrictions on union insignia. So let's say you work in a particular location, it could be Walmart, it could be somewhere else, and you want to wear a union button or a hat or a t-shirt. Generally speaking, if you're allowed to wear something of your choice, it is unlawful for an employer to say you cannot wear a union hat, button, t-shirt. In the Walmart case, the Trump board looked at the Boeing test and policies that said employees may wear only small, non-distracting union insignia in the workplace. The claim was made that Walmart's policy unlawfully infringed upon employee rights. but Walmart said its policy was lawful in order to deal with customer-facing areas at the store. But the policy was unclear as to employee-only areas. So the board looked at two types of employer policies on buttons and insignia. And where an employer bans the wearing of all union buttons and insignia, the board and Supreme Court have found that such rules are presumptively unlawful. So you can't forbid it altogether. The burden is placed on the employer to justify the rule on account of special circumstances, and that's a very narrow exception. But where an employer such as Walmart instead allows some buttons, but limits the size and or appearance of buttons and insignia that employees can wear, the board held that the Boeing test for facially neutral rules applies instead. And there's a greater likelihood of being able to do that. The board didn't overturn the special circumstances exception, but the decision suggests that the Boeing test might be applied to issues where the board previously set higher standards for other types of workplace restrictions. So this is something that employers, employees, and unions were all looking at with great interest. This is a case targeted by the labor movement, and I am expecting that the Biden board, through careful prosecution decisions from the new NLRB General Counsel, they will find a way to challenge and modify this standard in cases to come. Another big issue has to do with confidentiality of workplace investigations. And if you've dealt with workplace investigations before, you know that it's important to protect the integrity of the investigation, to get all relevant information, to ensure that witnesses and evidence are protected, to maintain neutrality. And of course, it's important to avoid, one witness influencing the testimony of another. But what we've seen is that, sometimes employees talk about this stuff. Maybe they tell other employees, what they've recited in the investigation. Maybe they try to convince other employees to say the same thing. There are a lot of concerns that come about that. And the National Labor Relations Board, particularly during the Obama years, took the position that employers were very limited in their right to demand confidentiality of employees during the course of the investigation. They might have a greater right to do so with supervisors who are actors on behalf of management, but with regard to rank and file employees, it could infringe upon the employee's rights to demand confidentiality about what was said in the investigation. There was a case called Banner Estrella, which came out in 2015, which addressed a legal standard that the board wanted employers to apply to assess the situation before demanding confidentiality. My guess is we're going to go back to a Banner type of standard under the Biden board. But key case here and current law now is Apogee Retail, a 2019 decision. And in that case, Apogee, the board found a company rule requiring employees to maintain confidentiality and prohibiting unauthorized discussion about workplace investigations into illegal or unethical conduct was not unlawful. In other words, Apogee said the employer could lawfully demand confidentiality. And the board relied on the Boeing decision, which we mentioned a moment ago. The board overruled the Banner case, and the board said that Banner incorrectly placed the burden on the employer to demonstrate whether confidentiality concerns the employer had outweighed the employee's Section 7 rights. I expect this to ping pong back to the Banner standard under the Biden board. And the board noted in Apogee that the Banner test often conflicted with other federal regulation. And a case that I handled, Hyundai American Shipping, is an example of that, because one of the arguments there was in refusing to allow employers to maintain confidentiality, the Banner test infringed upon EEOC rules and guidance encouraging confidentiality. So this is going to be a tough issue as employers try to recognize employee rights, conduct neutral, complete, and fair investigations, and comply with laws such as sexual harassment, and to deal with whatever needs to come of a particular investigation. Again, this will be a target for change in the standards with the new administration. Another big issue involving protected activity and policies has to do with employees' use of employer information systems at work. In particular, the Caesars case from 2019 involved an employer imposing restrictions, including outright bans on the use of employer-owned information technology systems, including its email system, for non-work purposes. In other words, if an employee wants to send an email about something personal business or trying to organize a union on the employer's email system, the employer would like to restrict that activity. Now, in 2014, a very important board decision came out in a case from Southern California called Purple Communications. And in Purple Communications, the employees were involved in sending non-business information on the employer system. The employer tried to forbid and punish that, and the board said, no, employees have a presumptive right to use the employer's system, which they use at work, for personal or union organizing purposes, assuming that there is no consistently enforced ban. So in Caesars, the board moved away, the Trump board moved away from what the Obama board had allowed in Purple Communications. Caesars said the employer could provide restrictions, including outright bans, and they recognized an exception where there are no other reasonable means for employees to communicate with each other. And I would imagine that is a very narrow set of circumstances. Perhaps you have employees working remotely and unable to communicate with each other, through other practical means. So in the pandemic, query whether there are, more exceptional circumstances than perhaps in other times. But I, again, expect the Caesars case to be attacked in legal proceedings to come, and the general counsel and the board to look to reimpose a standard like Purple Communications, giving employees greater rights to communicate in the workplace via email and other information systems used in the workplace. Now, employee use of personal cell phones at work has been a hot button topic for a number of employers who want to keep productivity at the forefront, and perhaps there's an issue about employees being inattentive or not getting the job done, basically. And the Obama administration and its iteration of the National Labor Relations Board gave employees greater rights in terms of what they could do regarding communication in the workplace. The Trump board reined that in the 2020 Argos decision, which is referenced here, where the employer suspended an employee for having a cell phone in his concrete truck in violation of the company's cell phone policy. So simply having a phone in the truck violated the policy. And the board again cited the Boeing decision, which we mentioned, and relied on legitimate justifications associated with the rule, outweighing the potential impact on the employee's rights under Section 7 of the National Labor Relations Act. And they talked about the dangers of using cell phones while driving. So that's an interesting analysis, but I think that the Biden board will look to change that. And there's also reference to the 2020 Cott Beverages decision, which involved a cell phone restriction on the shop floor of the employer's facilities, and the employer's justification there outweighing employee rights. So I think we're going to start to see rulings from NLRB where the employee rights are going to outweigh the employer interests that were previously relied on in Argos and Cott. Solicitation during working time is a multidimensional issue because it could be employees handing things out to each other. It could be employees talking to each other. It could even be some non-employee wandering around in the workplace. And in the Wynn Las Vegas case from 2020, the Trump board talked about solicitation in the context of encouraging employees to vote for or against a union in an election. And the board determined that the employer lawfully disciplined an employee for violating the no solicitation policy when she urged another employee to vote for the union. And there was some discussion about, whether solicitation actually requires, the distribution or tender, as stated here, of a union authorization card. But solicitation, according to the board in the Wynn Las Vegas case, doesn't require a significant, if any, disruption of work to violate a no solicitation rule. And I expect this ruling will be targeted as well to restrict what employers are allowed to do, to restrict employers' ability to control and limit employees' activity in the workplace, particularly given the very vehement support for unions, which this administration has made public. The duty to bargain is a topic which will receive attention as well from the board and the new administration. The MV transportation case cited here is of great concern to employees and unions. Unions have really been concerned because when you have a bargaining relationship and a duty to bargain, an employer has an obligation to notify and to offer to meet and discuss a proposed action if it involves wages, hours, or terms and conditions of employment. And what the MV transportation case from 2019 stands for is that if there is reference in a contract to a particular subject matter, if an employer can find some justification in contract language to start moving forward with a course of action, there may not be a need to notify or bargain with the union. And this goes in a different direction from the longstanding legal standard that preceded it, where under labor law, there had to be a clear and unmistakable waiver for an employer to do something without bargaining with the union. And a clear and unmistakable waiver would be, for example, some sort of contract language saying that the union understands and agrees that the employer may take certain action or maybe, may have some discretionary authority to do something. And that sort of language doesn't come up all the time, but once in a while it does, that would meet the clear and unmistakable waiver standard. But with MV transportation, employers felt at greater ease to take steps that they would otherwise have had to take the time to notify, offer to meet, and then to discuss. So this is something that the Trump board applied retroactively, and we will see that it gained some attention from the Biden board. In 2020, MV transportation has been applied, such as in the ADT case. An employer was permitted to implement a 6-day work week under MV transportation, where the collective bargaining agreement, CBA, stated that the employer had the right to determine the reasonable amount of work that was needed in that particular workplace. In the Huber case from 2020, an employer's changes to attendance policy were deemed to be covered by a management rights clause that permitted adoption of reasonable rules and policies after input from the union. MV transportation remains the law, but this is another one where I expect there to be efforts to change it. Here's a few more. Smith's Frozen Foods, an employer's unilateral change to its drug and alcohol policy. Unilateral change meaning unbargained change. Expanding termination to off-duty use. That was okay under MV transportation. Michigan Bell Telephone, a provision covering employee compensation for union time, didn't cover the question of an employee's status as an employee or a full-time union official, and therefore the employer had to bargain to change the employee or the party's past practice. So that was sort of a limitation on the contract coverage, because they were able to say from the contract terms that it did not get to that issue at least close enough to allow the employer's actions. Apex Linen, the NLRB dismissed a unilateral change complaint based on the MV transportation standard, where the contract gave the employer the right to make and enforce work rules, even though the employer had never previously enforced safety or work performance rules previously. So that's something where, yeah, the employer's actions may not support it, but the contract language ostensibly did. So this is something where the unions feel they're being left in the lurch, and I expect that they will be doing what they can to raise charges to challenge this legal standard, and the board will be looking for those opportunities as well. So deferral is a labor law doctrine where the labor board may not take action. They may elect not to if there is a grievance arbitration procedure that would enable the parties to resolve things among themselves. There is a general counsel memo, OM 20-03 from 2019. And the essence of that is if there is a claim by a union that an employer has violated the duty to bargain, and in light of MV transportation, if there is no arguable merit to the claim, the charge would be dismissed. If there is arguable violation and a grievance had been filed, the board would defer under what it calls its DUBO rule. If there was an arguable violation and no grievance yet filed, the board would defer under its Collier rule. Again, these are two different types of deferral that the board has acknowledged over the years to the grievance arbitration process. So this is an interesting notion when the bargaining process is alleged to be failing, that the board would defer to the party's chosen machinery to resolve it rather than the board acting itself. I expect that this guidance will be cast aside under the Biden board, and the board will take a more active role in challenging employers who make unbargained changes. During the Obama board period, an issue arose about whether an employer had a duty to bargain over the discipline of employees, particularly when there was, say, a newly unionized employer that did not yet have a collective bargaining agreement. The Obama board took the position that yes, the employer did have a duty to bargain, and there's a case cited on this slide, Total Security, which stands for that proposition. That's a 2016 board ruling. Well, the Trump board in 2020 had the 800 River Road DBA Care 1 ruling. And the current rule, because of the Trump board ruling, is the board said the employer had no duty to bargain before disciplining employees during the commencement of a collective bargaining relationship where there was no collective bargaining agreement in effect. So this is another one. I am expecting it to be overruled by the Biden board, and a newly unionized employer will be required to bargain over discipline of employees, particularly where there is no new collective bargaining agreement to cover those issues. And this is to protect the employee as well as the union's role as representative of employees in that newly unionized workforce. So we've got some big issues as it relates to the COVID pandemic. And as you might expect, some of the things that normally go on in the labor law world changed quite a lot because in terms of employees communicating with each other, employees working with labor unions as their representative, and labor unions' ability to communicate and bargain with employers, really the chemistry changed. And like the slide said, the world is temporarily closed, but I think most of us have seen in our law practices and in business that we've looked and found ways to continue moving forward. And that's true in labor law as well. And I think one of the big questions is, from what we've learned over this pandemic period, what about that is going to stick post-pandemic? What about that is going to change areas of, I would say, traditional practice or custom in the administration of labor law between parties in dealing with the National Labor Relations Board and more. There is this notion of exigent circumstances, and this came up very early when the pandemic first started gaining national attention. The Trump NLRB said, there are emergency exigent circumstances which are going to need to be considered in the course of bargaining relationships, and where employers may have rights to do things without bargaining that they might have had to sit down and talk with the union about before. The same rules were confirmed to generally apply, but the board said the narrow circumstances when exigent circumstances relieved the employer from its duty to bargain, they got a bit more clarification. So in terms of bargaining obligations, generally an employer is permitted, at least initially, to act unilaterally, in other words, on its own without bargaining during emergencies, such as COVID-19. So long as its actions are reasonably related to the emergency situation. But the employer needs to bargain over the effects within a reasonable time. And it's important to know that over the years, the labor board and the courts have distinguished bargaining over a decision versus bargaining over the effects of the decision. And so this is one where even the Trump board acknowledged that there was some duty, at least to bargain over the effects of doing something, if not the decision itself. So importantly, and in the interest of public safety, it was determined there's no obligation to bargain over requiring employees to wear masks, and no obligation to bargain over a decision mandated by the state to transition to remote learning. But some of these things pop up, and they are they're decided on an issue by issue basis, particularly because the NLRB has been driven by cases, by the issues that are filed, rather than rulemaking and regulation, which is how some other agencies operate. So This is something that the board started looking at the beginning of the pandemic. And it's something that I expect the board to continue to look at, and we'll see what, if any, tweaks to these rules will follow. There are some other issues that warrant attention involving union representation, or in other words, elections, joint employment, remote hearings, and also the conduct of elections during the pandemic, because it has changed things, and the level of interaction that people have had with each other is not what it was, of course, for safety and public health reasons. Now, the Trump board launched into rulemaking on a number of different issues, which led to regulations which are likely to stand for some time unless the board goes through the notice and rulemaking process yet again, which is very time consuming and takes a lot of effort. These topics are important to know, because if you've ever been through an NLRB election campaign, you may have seen, for example, with blocking charges, that one party or another files an unfair labor practice charge, and there is a question whether that charge will stop the election process. And because of this new regulation in 103.20 of the board regulations, the filing of an unfair labor practice charge will typically not stop an election from taking place. And instead of stopping the election, ballots will be impounded until issues are resolved. Another regulation has to do with voluntary recognition. And under that section, an employer or a union must provide notice of voluntary recognition, creating a bargaining relationship to NLRB and affected employees. So envision a situation where a union comes to an employer, demands recognition. The employer says, okay, I will recognize and bargain with you, but maybe there's been no showing that a majority of employees actually wants that union. So what this regulation requires is that the employer or union tell NLRB and post a notice for a period of time during which employees may file a petition for an election if they want to challenge the employer's recognition of the union as the employee's representative. There was a similar rule that the board came about with through a ruling in the Dana case in 2007, and that case was later overruled. So this voluntary recognition bar is something that the Trump board wanted to do. Unions have criticized it as a way to undermine bargaining relationships. The people who advocate for this rule say, hey, look, an employer and a union can't take away the rights of choice of employees. And if employees haven't had a say, they should have a right to vote. So there's definitely different viewpoints on this, and whether the recognition by an employer of a union will be given a preclusive effect against a challenge through an election petition later on. So anyway, this posting will likely be under attack by the Biden administration. I would expect this will be targeted in some way before too long. The last bullet point on this one is specific to the construction industry. And actually, I handled the Colorado fire sprinkler case, and this has to do with sort of a nuanced rule unique to construction, where employers and unions can sign agreements and can recognize a bargaining relationship without proof of support from employees. But the question is, how long does that relationship last? And it's typically going to be limited to the term of a contract pursuant to this rule, unless there is something establishing employee support, actual evidence of majority support from employees, which could then provide the foundation for a longer term bargaining relationship. So in construction, it's typically contract to contract when you have a bargaining relationship. The joint employer issue has been a hot button topic for labor law for a number of years. And the NLRB issued a joint employer rule in 2020, and the rule overruled an Obama board decision in the Browning-Ferris case, or BFI, and imposed a stricter standard. For many years, the NLRB would not find joint employer status to impute liability to more than one employer, or indeed to impute a bargaining relationship to more than one employer in the absence of actual control over some aspect of wages, hours, or working conditions. The BFI case, which was overruled, allowed joint employer status to be imposed based upon actual control or potential control. So the Trump administration reined that in, said we're not going to allow just potential control to be the determining or to be a determining factor for joint employer status. So we'll see whether this rule stands up to scrutiny of the Biden board. I expect that this will continue to be a hot button decision. Remote hearings are a topic that have come up as a result of the pandemic. And I think they are something that we will continue to contend with as the pandemic passes us, because I have a feeling that most people aren't going to want to have to pay to go to an NLRB office to try a case or to do an election hearing, if it can be done more efficiently via remote proceedings. So NLRB regional offices have been ordering representation case hearings over Zoom and other video conference platforms. And the NLRB's Division of Judges has ordered unfair labor practice case hearings, also known as C case hearings, to be conducted over Zoom as well. So over the last year plus, the labor board and practitioners have, I think, in many instances, worked out concerns and ways to address hearing issues, how evidence is handled, how witnesses are questioned, and so forth, to make the process run smoothly. And NLRB has been quite proud of its efforts, and much like the courts, have done their best to continue to keep operating during challenging times. And also important to continuing operations during challenging times, a very, very important job for the labor board is conducting representation elections, where employees vote yes or no on whether or not to be represented by a labor union. And at a time where social distancing and public health really took front page attention, the board looked at those issues, and they had to really reassess their rules. How can we conduct elections when it's not safe for people to get together? The historical and preferred method of holding elections for decades with NLRB has been in-person balloting, or what they call manual balloting. And voting by mail has been an option, but typically a narrow exception to the general rule of in-person voting, typically confined to situations where employees are spread across a remote area and it's impractical to have them drive to let's say the employer's place of business, to conduct a vote. Well, in this case, Aspiris Keweenaw, which came out in 2020, the board actually set standards to determine when, in the pandemic environment, elections should be conducted in person rather than by mail. So there are a number of factors that the NLRB has looked at since 2020 and continues to look at as we continue to muddle through the pandemic. And the factors that they look at include, whether the agency office, in other words, NLRB office that you're dealing with, is under a mandatory telework status. That may or may not be the case. Whether the 14-day trend in the number of COVID cases in the county where the employer's facility is located is increasing, or whether the 14-day positivity rate in the county is 5%. The third factor, the proposed manual in-person election site, whether that can be established in a way that avoids violating mandatory state or local health orders relating to maximum gathering size. So you can see federal law trying to harmonize with the many state and local rules which we've been dealing with since the pandemic began. Number four, the employer fails or refuses to commit to abide by protocols that had been set by a previous NLRB General Counsel memorandum. So, all these again are considerations which may or may not be the case. Number five, they look to whether there is a current COVID-19 outbreak at the employer's facility, or the employer refuses to disclose and certify its current status. So that's going to be individual to each location, each employer. And they look to other similarly compelling considerations. So there's a lot of factors that the NLRB is looking to in determining the method of holding elections. But by and large, since the pandemic, the elections have been done by mail. And it's generally going to be the NLRB opting for what they consider the safest way in which to hold the vote, and by doing so, that will hopefully encourage employees to participate, because a failure to participate in an NLRB election is a concern as to whether employees have been in fact disenfranchised, denied the opportunity to vote. So that's always a concern to NLRB. So there are a number of things that I want you to be aware of beyond what I've talked about already that are likely areas of potential change and reform. And so I'm going to run through those very quickly. But in the short term, there are a couple of general counsel memoranda that the new NLRB general counsel, Jennifer Abruzzo, put out in recent weeks. This is being recorded in August of 2021. General Counsel Memorandum 2104 highlights priority issues for change. And there are a number of those that I've talked about during the course of this presentation. And there are even more, such as misclassification of individuals as independent contractors, and whether that is a deprivation of rights under the National Labor Relations Act, such that those individuals cannot form a labor union. There's also General Counsel Memorandum 2105 on the use of injunctive relief. What does that mean? Well, the National Labor Relations Board allows for an administrative process. Let's say there's a claim that someone committed an unfair labor practice. There's an investigation, there's an administrative hearing, there's possible federal court litigation on enforcement of the results of that administrative litigation. But if the circumstances are urgent enough, perhaps it's an emergency where employees' rights are in danger, or the remedial system that NLRB has in place is likely to fail because of what's going on, the NLRB, as discussed in Memorandum 21-05, can use injunctive relief. That is a discretionary choice by the agency, not by private practitioners, to go into federal court to seek an injunction to stop the unfair labor practices so that the administrative proceedings can go forward. So if you as a practitioner are looking at a violation where there is a threat of remedial failure, asking for Section 10J relief may be appropriate, and it may be something the agency is thinking about when they hear the facts of your case. So fairly traditional injunction factors, irreparable harm, and things of that nature, balancing of hardships come into play, but the courts tend to want to grant the injunctions unless there is some delay or other flaw in what NLRB is trying to do. So it's a very effective weapon in protecting employees' Section 7 rights. In the longer term, there is legislation pending in Congress right now. The Protecting the Right to Organize Act, known as the PRO Act, would significantly modify the National Labor Relations Act, would create penalties for employees who, for employers who violate the labor law. There are no penalties or fines right now. The remedies are make whole, meaning that you restore status quo prior to unlawful conduct. There would also be a modified recognition process for employers and unions to begin a relationship, and that would be done with cards rather than with secret ballot elections that we have right now. And there's a number of other issues, possibly incorporating the ABC test that is used in California to determine independent contractor status as a matter of federal law rather than the common law right of control test. So a lot of interesting things in that legislation. So that is on the long-term agenda. And there are other potential areas of reform, including regulations, executive orders, and more. We're seeing a time of incredible change, a time where safety is at the forefront of the workplace, and where in the non-union environment, there is great interest in expanding awareness of employees' rights to speak out and to take a position on different issues involving their workplace, maybe directly wages and benefits, or perhaps in ways that employers may dispute. They may dispute that they are relevant to work, issues such as social justice and politics. But these are areas where I expect, again, the labor board in the Biden administration to expand employees' rights and to challenge employers who dispute that employees have such protections. So it's an area I find fascinating. That's why I've been doing it for over 30 years. And hopefully you and your practice, if you deal with these issues, you take interest and you will deal with them knowledgeably and effectively. If you want to learn more about what NLRB is doing, you can do so at nlrb.gov, their website, and it is a really good resource. And as time goes on, they are doing more and more. They very recently added some new features, including active docket information, so that you can get updates on cases as they develop. There is no time for a question and answer session since we are recording this webinar, but I invite you to reach out if you have any questions. And this is always a pleasure to do this for the Center for Continuing Education. And with that, I'll conclude the program. Thank you very much.